Welcome to Inherently Distinctive.
Hello and welcome to Inherently Distinctive with attorney Mark Goodman. Mark's practice focuses on patent law, trademark law, copyright law, and business law related to innovation. I am your host, Kevin Rosenquist, and today's episode is Trademark 101. What is it and how does it stand apart from patents and copyrights? Mark, welcome back.
Oh, it's great to be here.
Episode 2,
first
we made it.
episode off my chest, and now we're just rolling, right?
Now we're just going to go, yeah. Yep. So what is a trademark? How is it different from a patent or a copyright?
Okay, so trademarks, patents, copyrights, all of these are forms of what we call intellectual property, right? Which is an intellectual property is a property right created by the government to encourage innovation, basically, right? But they protect different things and they operate in a lot of different ways, right? I practice patents and trademarks, and some firms would only do patents or only trademarks, but they feed off each other a lot because a lot of the same folks are interested in patents that are interested in trademarks and vice versa. And they work together at the same office, the United States Patent and Trademark Office. So they go together really well, right? So to contrast, a patent is how you protect your invention, right? We talked about this on the first episode at length, right? You've invented some new widget and you want to be able to own the rights to that so that nobody can knock you off in terms of your technology, right? A trademark, by contrast, is how you protect your branding in the marketplace, right? So a trademark protects typically, let's say, the name of your company, the name of a product or service, or let's say a logo that's associated with a product or service or set of products or service, or a catchphrase even can be trademarked. So just think about this. Nike has a trademark to the name Nike, to the swoosh symbol, right? And to the phrase, just do it. And if you actually pump Nike into the trademark search system, you probably get about 168 results of different trademarks that they either have or have had in the past, let's say, as they build for small businesses and entrepreneurs starting. You usually want to just go for one or two or three trademarks that are most core to your branding and then build as your company builds. And so some basics about trademark law, right? Why do we even have this, right? There's really two main justifications, and they're kind of related to each other, which is one is that the government is trying to prevent consumer confusion in the marketplace, right? I always use this example, okay? Let's say, Kevin, we get tired of doing podcasts, right? How about you and I go into business and let's start a coffee shop, right? So
sounds good.
What are we going to call this thing? I don't know. I just came up with the name right now. How about we call it Starbucks? Sounds brilliant.
Does sound good.
Catchy. Yeah, it sounds catchy. Right. So if we did that, of course, we're going to be sued on the first day of operation, and they're going to bypass the normal legal process and just napalm our shop and vaporize.
That's right. Yeah. They're just going to blow us up completely. Yeah.
Right. But it wouldn't be based on copyright or property or patent or anything. It would be based on trademark infringements. Right. So that's kind of the sort of vignette you're thinking about with trademark. But why? So why should they be able to stop us? Well, a couple things. First of all, there'd be massive confusion because people would show up to our phony baloney Starbucks thinking that they're going to an establishment that's associated with, affiliated with, or sponsored by the Starbucks brand they know and love, but it's not, right? So a couple things. First of all, we're then essentially stealing from the Starbucks company because that's the revenue that we're getting is really ill-gotten, should be going to the Starbucks company.
Yeah, it's coming to us because of their brand recognition.
Customers wanted, right? That's one. And then the consumer confusion would also be huge. Like you'd go in and be like, is this really a Starbucks? This is not what I'm used to when I go to a Starbucks. Everything, the prices and offerings seem totally different, and everything's, I just wanted my triple mocha frappuccino and my whole day is ruined because I'm utterly confused about what's going on. And that is a harm to the public that we are redressing by establishing this wonderful trademark law, right? So that's kind of the basic philosophical underpinning of it.
How do you know if you're eligible for a trademark? How do you know if like your brand name or your logo, or, how do we determine that?
There's a few things that are relevant here. So first thing, I've got a few of my little vignettes here that I always go through is if you have a name of a business or product, you have a much better chance of being able to get trademark protection, and your trademark protection will be stronger the further you get away from describing what it is you're selling. So, and sometimes people, and this can trip people up because a lot of times business people want names that describe what they're selling. And the way I look at that is that that's fine. Just understand that we're now in a weaker trademark position if we want to do that.
Right.
So back to our example. Let's say we're not going to call our shop the Starbucks. Let's say, Kevin, we just open up a coffee shop and let's just call it the coffee shop.
Okay.
Awesome.
I like it. Let's keep it simple.
Right? Let's keep it simple, right? Totally fine. And we're allowed to do that, right? So we could operate generically. No one could stop us from doing that. But we can't get a trademark on a coffee shop and sue every other coffee shop in the universe because they're infringing. What are you talking about, right? Now, everyone kind of understands that intuitively, I think, right?
Sure.
But what they don't always realize is there's like a spectrum that flows from that. So let's say we call our coffee shop Hot and Fresh Coffee. That's not generic, but we're not going to get a trademark to that, right? Because shouldn't everybody be able to call their coffee hot and fresh?
Yeah, ideally, right? It's what it is.
I hope so, right? And then as you kind of walk away, it gets a little murkier, right? So that second example would be considered descriptive, right? If you call it coffee shop, that would be generic, right? You can never have a trademark on a generic name. Descriptive terms, you can have trademark rights, but it's more difficult. They're not as strong. So you got to think about that. And then when you flow away from that, you can have a name that's suggestive of what you're selling. Now, here's the problem. What's the difference between suggestive and descriptive? Well, we can get into arguments with the trademark office on that is the answer. Right. Yeah. But I'll give you some examples, right? In-N-Out Burger, I like this one. That's suggestive, right? You get in, you get out as fast, right? But it's not describing exactly what their business does like Hot and Fresh Coffee would, right? I think that's a little bit different. And then when you step away from that, you could have a mark that is arbitrary, which is a stronger from a trademark lawyer's perspective. Example, I used to use an arbitrary word. It's a word in the English language or another language. It has a meaning, but that meaning has absolutely nothing to do with what you're selling. And there's almost like a relativity principle that applies here, because we're always looking at the name relative to what you're actually selling. I use this example all the time. Apple computers. Apple is a great trade name for computers, smartphones, tablets, streaming music services, whatever else they do, right? But let's say the Apple computer company decided, hey, we're going to leverage this brand, Kevin. We're going to buy up a bunch of orchards and sell apples. Well,
going into Apple business.
They can do that, but they can't sue people for calling it Apple and Apple. In that field, it's generic, obviously. Right. So that's kind of the next. And so arbitrary marks are great, right? If you pick just some word that you think is cool or whatever, but it doesn't have to do with what you're selling. And then an even higher level are fanciful marks, right? Fanciful means it's not even a word, right? And people make up these things. It's funny because I feel like this pharmaceutical company, I don't know if this is driven by trademark law at all, but they're the best at this. They have all these names for drugs and they're just all this gobbledygook, Rinvoq or Dupixent or, Ozempic and what have you, right? They don't have any meaning. So these are going to be strong trademarks. Again, I'm not sure if trademark is driving it. I feel like they have a bunch of people sitting around, getting creative and coming up with all this stuff, which is good for them. It's appropriate for what they're doing.
I've heard that they do that too, because they try to make sure people don't get confused between different medications. Yeah.
And that part of it, because remember, like I said, trademark law is the whole point of it is to prevent consumer confusion in the marketplace.
Right. Yeah.
Say, this is your stuff. This is my stuff. Right. Because one of the things that happens is let's say you're operating a business, you have, let's say, a trade name, right? And somebody else is in the same or similar field and their name is the same as yours or similar. Now you're going to have all this confusion. People are going to be calling them thinking they're calling you, and you could lose business. Or they could go to them and put a nasty 1-star review on your website because they had a bad experience over there. And you're like, well, I didn't even do anything with you, right? So it's a mess, right? And that's why we want to have our own name and get out of other people's way, ideally, right?
So you and we're starting a coffee business. We've got a name. How can we search it out? How can we find out if someone's already trademarked it?
Everything that is filed in the trademark office is public immediately as soon as it's filed. There's no friction. You don't have to get a login or pay money or anything like that to even get the information, right? So it's pretty open that way. So there's some good ways to search it. So there's different levels of searching. And I think and this brings up one of my other little vignettes I always use with clients, right? Which is I analogize your trade name to, let's say meeting somebody for the first time, and then maybe you go on a first date, and then maybe you go on a second date, and then maybe a few more dates, and then you're engaged, and then you're married, and next thing you know, you're married with 4 kids and a house and a 401k together, right?
And my goodness, Mark, you work fast.
The longer, I'm already pretty much at that last category, right? But the longer you've been in business and more you've invested in a trade name, the more married you are to that trade name, right?
Mm-hmm.
So in your example, if you're just coming up with a new name, you definitely want to start with a trademark search before even thinking about applying, right? And, we can take care of that for a pretty moderate flat fee on, to both the 2 main places you'd look. One is just Google on the internet, right? Is there somebody selling something, regardless of whether they have a trademark or not? Even if they don't, you don't want to do that. You don't want to just copy their name, because you can still end up in a fight with them, even if they haven't filed an application or registered it yet. And then as well, you would search the trademark records and see what's close. Now, the hard part about it isn't just that there's a lot of judgment involved in this search and analysis, right? Because trademark includes scope beyond what is, and just to finish my other point about this is that, like, let's say if you're in a new business, right? If you do a search and there's some stuff that's concerning, right? Little bit, well, this could be an issue. Maybe it is, maybe it isn't. Let's say I'm on the fence about it. Let's just get creative and come up with another name, right? And then try that, right? So, and try to find something where we're really confident that we've got some space to get our trademark rights established, right? And to not be in a big fight with somebody. On the flip side, sometimes people, for whatever reason, they've been doing business a long time, haven't gotten a trademark. I had a client a couple of years ago that came in, and she had been doing business under a certain name for 20 years. This was like her 20th year in business. And for her, I'm not even thinking about searching. I'm like, let's file and get this if we can, right?
Yeah.
Because we're already married with 4 kids and a house together with this name, right? And so unless we're just absolutely getting beat up in court or something, we want to get it. But for a lot of the new business, if you're launching either a new product or new service within your business or starting something new, let's think about this as a first date. You go on a first date and the person's crazy, we're done, right? Like, let's not like but can't we get it through, or could we push it through? Maybe, but why? You're cost a lot of money. It's going to be, just get creative. You'll find something that you like just as much, and we'll roll with that.
So after that, what's the next? How's the process unfold? What's next after you did your search? You're like, all right, I can do this name. I can get this name. What's next?
Yeah, so then we just prepare and file a trademark application. Typically, if you're selling between states, we usually just go with a federal registration, right? Incidentally, there are trademarks operate at the state and federal levels. It's a little unusual that way, right? You can get trademarks, I think, in every state or federally, right? To get a federal trademark, you have to be selling in interstate commerce, but that's a pretty low bar. Like even, restaurants in New York City have actually, and they had to fight over this a little, but they can get a trademark because people go to New York because they have great restaurants, for example, right? Mm-hmm. So you don't have to have like this nationwide presence to get a federal trademark registration. So that's kind of cool. You can have just a fairly moderate business and get it done. And you prepare and file an application. There is an examination process. There'll be an examining attorney assigned to it. They'll search and look at potentially conflicting marks in their records as well. They'll evaluate it for other legal issues, like if it's too descriptive, for example. That would be something they'd look at. And you kind of go back and forth a little bit and hopefully get it registered, right? If they reject it, then you can come back and argue with them that they're wrong. You can appeal it to the board. You have those types of rights. Or make amendments and say, all right, as amended, we think it's in condition to be registered.
How long do they last?
So this is the cool thing with trademark, right? We talked about this last time. Patents last 20 years from the day of filing. Yeah. Trademarks last forever as long as you keep them renewed, right? So just think of any ancient company, right? Northwestern Mutual has been around since before the Civil War, right? But they still have a trademark to their name and their logo and whatnot, right? Mm-hmm. And the longer it's been going, the stronger it becomes. So for the renewals system, right? Say we get our trademark this year, right? Our first renewal will be due between the 5th and 6th year anniversary of the issuance of the trademark, right? You can't file early because the idea with the renewals is you have to show you're still in business at that later time, right? Because if you end up ceasing business under the name, then it goes away, right? But as long as you're still using it in commerce, you can keep it forever. And that's why I always think of trademark. It's really pretty, compared to most legal work, a pretty darn good investment, because you can keep this thing forever in your business.
Yeah.
And money-wise, anything involving lawyers is expensive, but compared to almost any other legal problem you might have, it's not that expensive to get. So I think it's a great value that way. And then your other renewal at about the 10-year mark, and then it's just every 10 years forever after that. Keep this thing going.
Keep it going. And do you need a lawyer to do this, or can you do it on your own?
So similar to our question last time, I think in trademark, you see more people try to push it through on their own versus hiring a lawyer. But like I said, I think it's, compared to almost any of the legal problem you'd have, it's not a terrible amount of money. So I think it's worth doing. There are some pitfalls that you can run into if you don't know what you're doing in this. One of them is making sure that the goods and services description is accurate and correct, and it is something that the office will accept, as well matching the branding with the specimen of use that you provide. One thing about trademark that's different from patent, like we talked about last time, if you, we didn't clarify this fully, but let's say, Kevin, you come up with an invention, right? You said you never would last time.
I did.
Let's just say you did come up with an invention. You could think, man, this is an amazing invention. You hire Mark Goodman, file a patent application, we get a patent. You now own this space. And you don't ever have to actually do anything in the marketplace, right? Other people start doing it, you could sue them, or you could just sell the patent to somebody for $1 million, or maybe they would give you 5% of all their sales for the life of the patent, and you could make millions of dollars doing that. Like you have that. Whereas on the trademark side, trademark is based on real use in commerce, right? So you can't just file and lock down a name without actually selling a product or service in commerce. Now you can, though, however, and this is important, you can file ahead of it. So let's say you're launching a new product and you want to use a certain name. What we'll very often do is file an intent to use application. We say, hey guys, we're intending to use this mark in this field, right? Then initially the office will hopefully clear it against any conflicts or other legal problems, issue what's called a notice of allowance. That doesn't mean you have the registration yet. That just means you now have a time period to show them, okay, we're now in commerce doing this, right? Selling. By contrast, like you actually at some point have to be selling, or else you don't get the mark.
Right. Yeah. You can't just trademark anything. You got to have a use for it.
Right.
Well, I believe we're going to do a whole episode on the do's and the do-it-yourself versus getting a lawyer. So I'm excited to talk about some more aspects of that for sure. And thank you for tuning in to Own Your Genius with attorney Mark Goodman. To connect with Mark, visit goodmanlawnevada.com, and please like and subscribe to our channel and leave us a review. We always appreciate it. Mark, always appreciate your time. Thanks so much for being here.
Okay, perfect. This was amazing.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.